Hello friends, in the series on the income tax cases, today we will discuss the case of Principal Commissioner of Income Tax versus Narayan Kumar KHAITAN. This case has been reported in 454 ITR at page number 766 and the date of the judgment is 14th February 2023. The matter has been decided by Orissa High Court. Friends, this case is regarding section 292BB, which is about notice deemed to be valid in certain circumstances. The crux of the section 292BB is that if during the assessment proceedings, the assessee takes part in the assessment proceedings, then after completing the assessment, the assessee cannot take this ground that the notice has not been served on me, the notice has not served on me in time, and the notice has not been served in a proper manner. Subject to that, if during the assessment proceedings the assessee takes this plea that the notice is not served on me, not served on in time on me, and the notice is not served in a proper manner, then section 292BB does not apply, meaning thereby that it is the duty of the assessee during the assessment proceedings to challenge the validity of the notice regarding the notice is not received by the assessee, notice is not served on time on the assessee, and notice is not served in a proper manner to the assessee. If the assessee takes this plea during the assessment proceedings, then the assessee can take this ground at the later stage also. This is the background of section 292BB. In this case, the assessee assessment was going on, it was completed. After that, the Principal Commissioner of Income Tax initiated revision proceedings under section 263 by issuing the notice to the assessee. When the notice was issued, at that time the assessee was in judicial custody. The employee of the assessee appeared before the Commissioner of Income Tax and intimated to the Principal Commissioner of Income Tax that the assessee is in judicial custody. The Commissioner of Income Tax took the appearance of the assessee before him as the service of the notice and completed the revision proceedings without serving the notice to the assessee who was in judicial custody through the Superintendent of Jail. When the revision proceedings were completed, the assessee took the plea before the ITAT that the notice is not served on me. Section 292BB does not come to the rescue of the department. The assessee said that the employee was not my authorized representative, and the ITAT held that it was the bare minimum requirement on the part of the Commissioner of Income Tax, who got this information that the assessee is in judicial custody, that the notice of revision should have been served to the assessee through the Superintendent of Jail when the assessee was in judicial custody. The ITAT said that the officer of the rank of Principal Commissioner of Income Tax should be conscious in issuing the notice to the assessee in a sensible manner. The department moved to the High Court, and the High Court also upheld the order of the ITAT and said that in this case, the service of notice has not been done to the assessee. So, whatever the revision proceedings has been taken by the learned Principal Commissioner of Income Tax, that are not valid. Friends, this case gives a very strong takeaway for all the assessees that if you want to challenge the notice about its service, whether it is in regard that it is not served on the assessee, not served on time, and not served in a proper manner, then it is the duty of the assessee to challenge the service of the notice during the assessment proceedings. Because once the assessee does not challenge this during the assessment proceedings, then the assessee loses its right to challenge at the future date also. Friends, this case is very important because in a number of times it happens that when the assessment are completed and the matters are for the litigation, then the assessee came to know that the service of the notice was not completed in a lawful manner. But if the assessee has not taken its option at the time of assessment proceedings, then it can create a little bit difficult situation for the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Narayan Kumar KHAITAN, and this case has been reported in 454 ITR at page number 766. The matter has been decided by Orissa High Court and the date of the judgment is 14th February 2023. Thank you, friends.